So tonight we would like to discuss historical jurisprudence, or put differently, understanding law through the lens of history. Uh, so historical jurisprudence basically seeks to explore how law is an outcome of historical and cultural developments. And it's put forward the claim that law is not merely a set of rules imposed from above, but a reflection of societal norms and values that have evolved over time. And this is very important because if you remember legal positivism, an impression is created that law is a top-down approach. Top-down approach in the sense that the sovereign or whoever is a lawmaker makes the law and is supposed to be accepted and lived by society, is supposed to be implemented. So from top to down. However, if you look at the basic thesis of historical jurisprudence, we will be told that law is rather a reflection of norms, values, mores, which have developed in society over a period of time. So on that score, you will appreciate that law is more of a process, if you like, if for want of a better, it's more of a process than an event. So law is not that which is just made, but law is that which has been forming, which has been emerging, which has been evolving over a period of time through various social interactions, social experiences, and realities. So that is the starting premise of historical jurisprudence. And as the name suggests, trying to understand law through the prism or through the prices of history. Historians will tell us that you cannot understand the present and make a meaningful projection or anticipation of what will happen in the future unless you understand what happened in the past and what made what happened in the past happen. In a much similar vein, that is what scholars within historical jurisprudence is inviting us to do as far as the nature, the essence, or the phenomenon of law is concerned. And for that matter, the focus of historical jurisprudence is essentially about evolutionary nature of law. And the emphasis is on how laws develop organically as a result of various socio-cultural and historical contexts within which a society operates. So therefore, law is not something which just happens. No, because certain experiences occurred in society, certain responses were generated, and people, as it were, subsequent to those experiences, begin to order their lives and their interaction with one another according to those responses generated from those experiences. And that is the organic development of law, which we are talking about. So how the various societal arrangement, cultural arrangement practices all impact on the way we do things, the way we try to regulate our relationships and all that. So one key focus of historical jurisprudence is the evolutionary nature of law. And then we've also talked about cultural and historical influences. And we are, or scholars within this particular school try to invite our imagination to go into how certain historical events, certain paradigm cultural shifts, certain major needs in our society will bring about significant development, significant changes in the law and how the law is interpreted. There are, if you take culture, for example, if you take even marriage, right? How marriage is contracted in various customary law communities, you will appreciate that the requirements of marriage as an institution have undergone changes. And these changes have impacted upon the legal recognition of a valid, let's say, customary law marriage. So that if there is a dispute as whether a certain alleged marital relationship between A and B is valid, the determination will be made according to the current understanding of, let's say, requirement of marriage under a particular customary law. And that has been as a result of various changes. For example, in the past, you have to have various things, poverty right and so on. The community, everybody know that, this person has actually been taken through that ceremony. You take like the people of the Krobos, for example, the depot right and so on, before the person will even become available candidate for marriage and all that. And if that was not done within a particular historical epoch, an argument to be made that the person could not be given in marriage and so on and so forth. But all those have actually changed. But just an example, or you take also when it comes to land tenure, right? When it comes to land tenure, for example, we have the Ebunu and the Busa, Dibinamin Dibi, concept. Now, if you look at the rights and duties of the parties to these arrangements, they have evolved over time. And we've even come to a stage of some of these transactions where it is required that you even reduce the terms of, let's say, the Bunu or the Busa agreement or arrangement into writing. That is, if you like, part of the current understanding of the law, but that was not really the case. Or I'm even going far when it comes to strangers, right? If you take usufructuary interests, customary law, freehold, and all that, you notice that originally, if you were a stranger, you could get the land to work on probably through a Bunu or Busa arrangement and so on. But for you to get a very permanent stake in the land, which is owned by there's two or the particular stain or the family having the allodia. That was originally not possible. But over time, you see how the law has evolved, and that which was previously not permissible is now permissible. So that is how the cultural and the historical influences actually tell us their impact on the development and interpretation of laws. Or again, I'll give you another example. If you remember the famous case of Henry Kofi Antubam, right? I think the Henry Kofi Antubam decision, which predated the promulgation of intestate succession law, 1985, PNDC law 111. Now, the ratio in Henry Kofi Antubam, among other things, was that where a man died intestate without making a will, the children of the deceased could live in his house so long as the children were of good behavior, meaning that in their own father's house, if the children were not of good behavior, the extended family had every right at customary law to send them out or to let them live. But as you notice, you look at the PND's law 111, it has come to change all that. So those are the kind of things that we are talking about. So how important is historical jurisprudence to you as a student as part of your legal studies? It is by looking at historical jurisprudence, it will provide an understanding of how our legal system, and of course, legal systems of other countries have reached their current state. And various principles, various practices, procedures, and institutions have not always been there. They have evolved. They have evolved. They have gone through changes, transformations, and the transformations that they have gone through as a result of certain happenings, certain developments. So things don't just happen. They happen as a result of a reason. So that is why it's important for us to be interested in historical jurisprudence and not just one of the check boxes you need to go through in your legal studies. And in fact, I like what we call like the legal history. I like legal history because legal history give you a deeper understanding of society and the law. And to some extent, historical jurisprudence gives us opportunity to get some of these things. And another important reason for studying historical jurisprudence is critical analytical skills, which will help you to acquire. Because this topic, as we discuss various aspects of it, we'll be relating it to our legal system, we'll be relating it to current legal practices, and we'll be asking you to try and draw certain comparisons. So by studying historical jurisprudence, you deepen your understanding of the historical roots of various institutions. You take something like the jury trial by jury, for example. As we speak now, there's a bill before going through the process to significantly change it. Then you want to understand, if you take like a jury trial, if you are to do historical review to try and find out how it has evolved, if you go back to the English law where we transplanted jury trial from, you will notice that we have modified and tweaked it here and there. And even as we speak now, we are still going to do more. And then you want to understand why. Because of lived experiences, because of certain developments in what? In society. And then currently, we have what we call the plea bargaining law. We have a more, of course, plea bargaining in a very limited sense has always been part of our law, but we have now put it on a more comprehensive pedestal. And you want to find out why is it that now lawmakers is encouraging people who have been charged with a crime to enter into plea bargaining arrangement with the state. Well, it may well be that if you look at, you do the history, I mean the research into the history of it, you notice that the concern about congestion in prisons. If people, for example, have been charged with certain offenses and they're prepared to make admission and even offer to pay whatever fine or whatever the value is, why do you take them through lengthy trial and then they will finish and you impose a custodial sentence on them? What do you gain? So we have a law which says that if a person is charged with particular offense and so on, and if the person is amenable to negotiation and reaching an agreement with the state, that should be possible. So all this are as a result of certain experiences, certain developments in our society. In the same vein, you are doing company law, so let me use company law as an example. We have our current Act 992, which came into force 2019. You want to find out, if you look at the new additions, the novelties which have been introduced. Why? Because of certain developments, certain observations, certain experiences, which the business community had when the Companies Code 1963 at 179, which has been repealed, was in force. Yeah, so studying historical jurisprudence is very important. And of course, the world is not, it's what do you call is a global village. We are interconnected. And for that matter, studying historical jurisprudence will help you as students to appreciate the diversity of legal systems and the influence of cultural differences on the interpretation and application of law, especially where we have cross-cultural legal interactions now. Now, when it comes to various aspects of international law, maybe probably international law proper, or we take maybe when it comes to international trade, right? We have the what do you call the WTO system, and then the various regional integration, which is permitted within the WTO scheme, including even the after that we have. You notice that different countries with different legal systems and different emphasis come together. But you need to evolve what they call a harmonized system so that you are able to have one consistent legal framework within which you can operate and interact. So studying historical jurisprudence, open your mind, and when you go into those areas, you're able to appreciate why certain things are the way that they are. Or even going back to international law, which we learned about the law of treaties, for example. You know about the law of treaties and the things which are there. You notice international arena, we have countries coming from different legal traditions, and yet if we look at the travaux preparatoires, that is the preparatory materials which preceded the crafting of some of these international instruments, you appreciate how important history is when it comes to law. So you are not wasting your time. What are the key ideas in historical jurisprudence? One, law as a cultural norm. As we have noted at the very outset, that law is not merely a set of imposed rules, but law emerges from the customs, traditions, and values deeply rooted within a society. So from the point of view of historical jurisprudence, law is a bottom-up, right? So we have like a bottom-up approach rather than top-down approach. Because from legal positivists, you notice it's rather a top-down approach. But historical jurisprudence is bottom-up in the sense that the customs, traditions, values, and we are talking about custom, we're talking about the social practices of society, which have crystallized over a period of time. Those are what we are talking about. And those are the things which actually give rise to law. And that is why we say that it's a bottom-up approach from the grassroots to the top, so to speak. And this implies that law is seen as something organic. Law is organic. Organic in the sense that organic is something which grows. It's not static. Organic has got dynamism. So law is living expression of the society's moral and ethical standards. Living expression of society moral and ethical standards. So law is not static. Law is organic. It grows. And of course, you are familiar with Justice Sowa's famous dictum, which has become a cliche in the Tufo versus Attorney General. I have been speaking in relation to just the Constitution, but I'm interested in the way that he expounded the idea that, if you like, the Constitution is like a living organism. It's capable of what? Of growth. And then it mirrors the history and then aspiration of the people and so on in their search for a just and a better society and so on. So that is the same point we are making here, that law is organic and is a living expression of society's moral and ethical standards. And in our country, we can talk about traditional norms regarding land ownership and family relations, which continue to influence formal legal processes and property law. So if you look even now at the Land Act 2020, Act 1036, you notice that customary land law interests have been put on the same pedestal as the received common law concepts of interest in what? In land. So if you look at if you take your Land Act and you look at the various things there, you notice that, and let me reach out just for my Land Act here. You will notice that when interest in land, especially section 1, we have customary tenancy, we have the customary law freehold. statutory interest, allodial title. All these are concepts which evolve from customs of the people. You go back to the original case of Henry Maine, when the court actually listed how the alludia, for example, may be acquired. And if we look at it, it's nothing more than the actual social practices of people which have crystallized over time to become a custom. In the same vein, when it comes to marriage too, if we are talking about marriage, it's not only about the ordinance. In any case, even when you are going to do the ordinance, marriage and all that, there is an inquiry which you need to respond that whether you have performed the customary or what is the status of the person. Have you performed, like, have you fulfilled any, like customary requirement as it were? So you cannot just go and do, let's say, ordinance without presenting the necessary bride price or the dowry and so on. So that is just an example for you. Video of, yeah. Another concept is what we call the Volksgest. Volksgest is a German word. So spirit of the people. The Volksgest, and later on we go and talk more about Carl von Savigny. He introduced the Volksgest, and by the Volksgest, it describes law as an embodiment of the common spirit or the collective consciousness of the people. So law is supposed to be embodiment, a reflection of collectively, what the people perceive. So the collective consciousness of the people. That, according to Carl Savigny, is the Volksgest. And he applies it that law must resonate with the inner convictions and daily realities of the people. So the inner convictions and daily realities of the people, and that should grow and evolve with time. And that is why we have already noted that law is viewed as organic. Law is dynamic, it's not static. So let's keep that in mind. So these are the building concepts, but we take the founding fathers, Sir Henry Maine, and then Carl von Savigny, and say a few more about what each of them propounded as far as their view of historical jurisprudence is concerned. The third general concept is the fact that those in historical jurisprudence, their views are generally antithetical, that is against codification. So antithesis to codification. They contrast sharply with the idea that law should be standardized and codified. So if you look at, maybe you've heard of Napoleon Bonaparte, of course, from the Roman Dutch law tradition, where he sought to codify law. Now, one key idea, which is extant in the various strands of historical jurisprudence, is rejection of codification. And that is why we say that there's this antithesis to codification. And the argument against codification is basically that codified laws can be rigid. Because codification, what is codification? Codification is systematic attempt to state the law on a particular theme in one piece of law. So you collect typically, you take something like Ghana, we used to have what they call like the Criminal Offences Code, Act 29. So the idea was that as far as our substantive criminal law is concerned, if you take Act 29, you are supposed to have, if you like, a very comprehensive view of what the law is. The company's code, originally, that was what was called company's code at 179 until 2004, when, as a result of the Statute Law Revision Commissioner's work, the late VCRAC Crab actually changed it from Companies Code to Companies Act because, of course, the benefit of hindsight, he would have appreciated that the original designation of it as Companies Code in 1963 was misleading, if not misnomer. Because if you look at 179 SF, for example, when it comes to provisions on directors, it will tell you that the duties of directors also include duties of directors at common law. So meaning that what you have in the so-called code is not exhaustive. And some of the laws are actually located outside the document you are calling the code. But of course, as I said, that is not a perfect example. But if you go to the countries which practice the civil law tradition, because they have a code in the most perfect sense of the word code, where the code is actually a compendium and systematic statement of the law on defined thematic areas. And if you take the code, the idea is that everything about that particular law, you are supposed to find the answer there. And that is why I said that historical jurisprudence scholars hold the view that codified laws has that element of rigidity and may fail to reflect the current values and needs of people. And what that means potentially is that it will stifle legal evolution. And don't forget that we have already noted that this school talks about the idea that law is organic. And law being organic means that, remember, you are biology, organic and inorganic. Organic is, if you like, inorganic, inanimate things, like it doesn't have life. Organic has life, meaning that it grows. Now, if you embrace the idea of cause, you are putting a fetter on the ability of the law to grow. And that is why it stifles legal evolution. Well, I wanted us to do a discussion, but because of time, I have done the discussion for you. So I will skip that because we need to finish this before we finish this particular class. So let's look at the founding proponents of historical jurisprudence. So one of the fathers of historical jurisprudence, if you're looking at it from Germany, is Friedrich von Savigny. He developed the idea, which you have already alluded to, the idea of the vox gest. And by that, he meant that law originates organically within the culture and traditions of the people. So law evolves from the culture and traditions of the people. And that means that law reflects the spirit and collective consciousness. So the collective consciousness is the Vosges, the spirit of the people. And he made the famous statement, if you take his original book, and this statement is this, that, quote, law grows with the growth and strengthens with the strength of the people, and finally dies away as the nation loses its nationality, unquote. So, of course, that is a quite profound statement, isn't it? That yes, law is organic, law will continue to grow, become strong, improve, and all that as the people also, their strength and development and other things go up. However, if the society as a nation loses its nationality, then that will also mark the decline of law. Law will also start declining or dying. And as we have noted not long ago, von Savigny was the historical jurisprudence scholar who seriously opposed codification. And he argued against imposition of universal legal code, like the Napoleonic one that I mentioned for you. And he would rather prefer that law should develop naturally from within the community. So from the various social practices and customs, right? Then law gradually evolved, just as we are used to in our community before we came into contact with the received Westminster type of legal system. That was typically so in our traditional cultural societies. The various practices and all that over time will crystallize to become, as it were, like a binding rule, and everyone will align and organize his or her life according to that. So let's look at that, of course, as we reflect on our own legal system. Von Savigny's approach has influenced how legal scholars view interpretation of laws, and also how historical context and cultural specificity is actually emphasized when it comes to interpretation of law. So, for example, if we are talking about approaches interpretation like the mischief rule, okay, the mischief rule of statutory interpretation, the basic idea of the mischief rule is that the particular rule or statute which is being interpreted should be appreciated as having been made by the lawmaker to solve a particular problem, to address a particular problem, to cure a certain problem or deficiency. So you can interpret it better if you try to find out what was the mischief, what was the problem that the lawmaker sought to address by passing that legislation. So once you identify the problem which the lawmaker sought to address by enacting that law, then you will propound interpretation which would advance solution to the problem which the lawmaker would identify. That is the mischief. And of course, that is consistent with thinking of a historical jurisprudence, so to speak. So, historical jurisprudence, as espoused by von Savigny, has also brought what we call the legal historicism, or the idea of legal history, as very important part in the law. And the idea that in trying to interpret the law, in trying to understand the law, we need to be interested in the past of the law. And that is what the mischief rule to interpretation actually seeks to do. Of course, the mischief rule seems to have been refined in modern times to become what we call like the modern purposive approach to interpretation. But that is the context, so let us keep that in mind. Another important proponent of historical jurisprudence can be found in England. That is Sir Henry Maine. So the other proponent we saw, Karl von Savigny, is a German, right? So he is speaking from the perspective of German experience. Now, we also have Sir Henry Maine, who is speaking from perspective of English law. So he was a comparative jurist and historian. Of course, comparative law and legal history go hand in hand. Now, unlike von Savigny, as far as legal evolution is concerned, Sir Henry Maine proposed that societies evolve from status-based system to contract-based system. So, and as you will see in the green color I put over there, he made the famous statement that there has been a movement of progressive society. I mean, the movement of progressive society has either been a movement from status to contract. So progressive society actually moved from status to contract. And what does it mean? Sir Henry Maine is trying to make the point that if you look at the past, society was based upon status, right? Depending upon the particular class of society that you belong. Because there was what you call the social stratification. You have the upper class, the middle class, the lower class, and so on, the elite, and all that. So that was status. And various relations, various transactions were based upon status. However, things change and things evolve so that our society became more and more progressive and modern. Status gave way to contract so that people now relate, people now deal on basis of contractual arrangement they have been able to arrange. Contractual terms they have been able to hammer out themselves to define their relationship rather than any superimposed or pre-existing relations imposed by status that as a person you may have very little control over. So that is the point that he is making. So there have been important changes in social structures, and those changes have also reflected in the law. Now, when it comes to historical stages of legal development, we are able to differentiate Sir Henry Maine from Savigny. Now, unlike Savigny, who focused more on the organic and cultural roots of the law, Sir Henry Maine, on the other hand, emphasized a more structured progression of legal systems from primitive to more complex forms. So, of course, they are all talking about some form of legal development, the fact that yes, law develops and all that, but they are coming from different perspectives. As we saw in the case of Savigny, he is saying that yes, yes, law is organic, and then law grows with the spirit of the people. So the voices, the collective consciousness. So as long as the people have their collective consciousness, and that is what makes them a nation, the law will continue to grow. And law will probably stop growing and will degenerate or decline when the people lose their collective consciousness. And that is what makes them a nation, when they lose their nationality, as it were. But then, Sir Henry Maine, speaking from a perspective of his lived experience within the English law and the English society, says that it is rather the fact that society had a primitive law, and this primitive law evolved to become complex law. And he, as part of that he observed that there has been a movement from rigid status-based system to a more flexible contract-based system. So in the past, if you were born into aristocratic class, I mean, that was where you operate. If you're born into the peasant, right, the lower class, the peasant, and so on, that is where you operate. If you're born into what you call the maybe the serfdom, that is where you operate. And there was a very limited social mobility to move from one social class to another and all that. So that was really rigid. But Maine makes the point that all that gave way eventually to a contract-based system. And that means that the individual now has a greater freedom. So now you can negotiate. You can hammer out terms that you want. So maybe in examination, for example, maybe students are giving Sir Henry Maine's statement. The movement of the progressive society has hitherto been a movement from status to contract. So with reference to appropriate examples, critically discuss this statement. So do you agree that what Sir Henry Maine is saying is true, that if we look at progressive societies, the basis of relationship, basis of engagement is now more of contract than status? In terms of methodology and significance to legal scholarship, Sir Henry Maine helped establish academic discipline of legal history. So if you go to UK, for example, legal history is a standalone self-discipline, and students even take up it as a model in either their bachelor's or at the postgraduate level. Now let's get a bit more detail into Savigny's principle, but I think I'll have to put a hold on it now because it's now 8:28. I think I have another activity. So we went here and then we'll continue at the next class. Unless someone has a question or contribution on what we are discussing. Otherwise, we end here and continue next class.